Good morning, everyone. It's time for y'all to conclude the conversation of how awesome your Valentine date was last night, and it's time for us to get commercial in here. It is February 15th. This is the Full Commerce Committee. I'll be your host this morning. I'm Kevin Vaughn, and we are now in session. Mr. Clerk, would you please call that roll?
Representatives Alexander, Boyd, Calfee, Camper, Faison, Haston, Hazelwood, Hodges, Holsclaw, Johnson, Lynn, Manis, Moon, Powell, Powers, Sparks, Thompson, Towns, Vital, Zachary, Vice Chairman Bricken, Chairman Vaughn.
I too am here.
Mr. Chairman, you have a quorum.
All righty. Thank you very much. Members, have we got any personal orders today? All righty. If we have no personal orders, we're going to get right into our scheduled programming. Chairman Zachary is first on our calendar today, talking to us about House Bill 170. Chairman Zachary.
Thank you, Mr. Chairman. Mr. Chairman, I do have an amendment that makes the bill, which is drafting code 13242.
We appear to be in sync, Chairman Zachary, so please share with us what's on your heart and mind today.
Thank you, Mr. Chairman. We're off to a good start. Members, so this piece of legislation that's in front of you, we presented this in Business and Utilities last year. When we presented this bill, it induced wailing and gnashing of teeth, created stress and tension, and I agreed to roll the bill to this year to allow all parties to work on it. By the fact that I'm in front of you right now means all parties did work on it because we've passed out of the subcommittee. This is a collaboration between TML, AT&T, and Verizon related to small cell sites. Back in 2018, many of us were here when we passed the Competitive Wireless Broadband Investment Deployment and Safety Act of 2018. When we passed that, a couple of months later, the FCC issued a new order which differed from state law. So what this piece of legislation does is puts us more in line with the FCC order, and it does 5 things specifically, Mr. Chairman and committee. And I'll read these and be very brief. Allows for the differentiation of small cell providers under an aesthetics plan, which is significant for communities like Farragut or Collierville or Franklin or Brentwood, communities like that across our state. It changes the fee structure, which again, everyone was in agreement to. It allows for a one-time installation fee, allows for an annual fee regarding right-of-ways, and then it clarifies items related to the allowable size of the small cell facility box. It also reduces the maximum height of the poles. If you're looking at the bill, Section 1 addresses the aesthetic plan. Section 2 is the enclosure size. Section 3 is the right-of-way. Section 4 is the fees and rates. And Section 5 is height. And with that, Mr. Chairman, I'll be glad to answer any questions.
All righty. Thank you, Chairman Zachary, and we appreciate your diligence in working with this issue. I can tell you that when you are not expecting some cabinetry or a facility to show up in front of your home, and suddenly one day it can be a shock. But we also understand the fact that people like an ample supply of bars on their phone. So thank you for navigating the treacherous waters that this had. So do we have any questions on the amendment? Any questions on the amendment for Chairman Zachary? If not, we will call the question because I see no questions for Chairman Zachary. So all those in favor of Amendment 013242, please signify by saying aye. Aye. Any noes? The ayes have it. So we are back on the bill. The amendment makes the bill. So anybody saving questions for this? Good thing. All those in favor of passing House Bill 170 on to finance, please signify by saying aye. Aye. Any no? You're headed off to finance, Chairman Zachary.
Thank you, Mr. Chairman.
But not right now.
Yes, sir. I'm going to stay put.
All righty, because I want to hear about House Bill 1867, as I'm sure my colleagues also do.
I'm sure they do, Mr. Chairman. Thank you. Thank you, Mr. Chairman and committee. I do have an amendment. Thank you, committee. I do have an amendment, which is drafting code 13342.
To have that similar I too have a similar amendment. I have a motion. Do I have a second? You are now in, oh, excuse me. Ah. Outstanding. That amendment requires no action because it's traveling with our bill. Thank you, Chairman Moon, for being ahead of the game there. But anyway, we have an amended bill. It is House Bill 1867. So share with us what happens here, Chairman Zachary.
Thank you, Mr. Chairman. Members in committee, I'll be brief, and if there are any questions, I'll be glad to elaborate further. Over the last 23 months, we have dealt with obviously a worldwide pandemic, and everyone knows what we've gone through. Our frontline healthcare workers have worked diligently for 23 months, 12 months roughly without a vaccine, and for the last 11 months, they've had a vaccine available. We have reached a point now where, according to an article in the Telegraph on February 1st, per the CDC's numbers, the case fatality rate and infection fatality rate for COVID is now less than the seasonal flu from 2019. States such as New Jersey, Delaware, Connecticut, Massachusetts, New York, states that are blue, we're a red state, states that are blue have begun removing mandates, removing mask requirements, moving back to normal. Unfortunately, the federal government has issued a CMS mandate for our frontline healthcare workers who have served so diligently. Many of them, they've all had the opportunity to get the vaccine. Many of them already have had COVID, which according to the CDC is having COVID natural immunity 6 times stronger than that of the vaccine. That was a report that was issued on January 19th. So with that being said, Mr. Chairman, to punish our healthcare workers who, for whatever reason, choose not to get the vaccine, be it a medical condition or religious exemption, is unacceptable. There are healthcare providers across this state that are denying religious exemptions, which could lend itself to Title VII implications. I have spreadsheets and emails here from those healthcare workers across the state who have emailed me. We received over the last couple of months over 300 emails from healthcare workers whose exemptions have been denied and they have been fired because they choose not to get the vaccine. According to the CDC director, on August 5th, the COVID vaccine does nothing to stop transmission. That's according to the CDC. That has been lifted up as the gold standard for most in this country. So if we're going to take them as the gold standard, they said on August 5th that the COVID vaccine does not stop transmission. So then why would we punish our frontline healthcare workers and deny exemptions because they choose for whatever reason not to get the vaccine? So this piece of legislation simply says, related to COVID-19, related to the CMS mandate, this is only applicable as long as that CMS mandate is standing, that any medical or religious exemption that is presented by a healthcare worker must be accepted, period, end of story. The medical exemption must be signed by a doctor. The religious exemption, the language in here follows Title VII, and they must submit a statement for a sincerely held religious belief in order to get that exemption. So all this has to be done in writing. We have had numerous conversations with the THA. As I said in subcommittee, I'm not going to, or in the civil sub and civil full, I'm not going to say they support the bill, but they are good with the language. They've collaborated. We've worked with our speaker. We've worked with the governor's office, worked with the Department of Health. The bottom line with this piece of legislation, it will save healthcare workers' jobs. There have been some questions from people on the committee. Is it perfect? No. Do I wish we could go further? Absolutely. But this takes a significant step in protecting the jobs of our frontline healthcare workers who, for whatever reason, choose not to get the vaccine, and this will protect their jobs. So with that, Mr. Chairman, I'll be glad to answer any questions.
Thank you, Chairman Zachary. Make sure if anybody has any questions for Chairman Zachary that you get Ben's attention so that we'll have a record of it. Thank you for your working with the THA on this. Chairman Zachary, I know that my personal feelings on this matter is I'm suffering from COVID fatigue, and it seems like the longer time goes on and the more data that we get, we were operating out of an abundance of caution, but sometimes we were, as I've said before, we hugged the puppy too hard because we loved it so much, and it was uncomfortable. And so that's kind of the way I feel about a lot of our actions with the benefit of hindsight, obviously, with the benefit of hindsight. So I know that I've got Representative Powell has a question for you.
Thank you, Mr. Chairman. And I guess I'm not going to get into a debate with you on your opening remarks. I have some difference of opinion there, but I did have a question about the specifics of the language of the amendment. So if I'm a patient and I'm at one of these facilities, Is there anything for me to know that somebody that is providing care to me has filed one of these exemptions and might not be adequately vaccinated against COVID-19? Because my concern here is for the consumer and the patients of the state who might be exposed. Is there any sort of way for them to know that? And then is there any sort of liability that worker might be held to because they've not been vaccinated? And if they then contract COVID and give it to others or spread it amongst their coworkers, is that addressed in your legislation?
Chairman Zachary.
Thank you, Mr. Chairman. In terms of each facility, that's up to them. I know some facilities, based on what nurses have told me, this is just the feedback I've gotten. Some of them on their name tags, they're clearly indicated whether they're vaccinated or not, or they have to wear masks, whatever it may be. So that is not addressed in this bill. That's per facility. And then in terms of risk of patients and transmission, again, as the CDC director said on August 5th, the COVID vaccine does nothing to stop transmission. So that's not applicable to this.
Representative Powell.
Thank you, Mr. Chairman. So just to be clear, in your language, it's silent on that point. If facilities still want to have identifying information to show that people have not chosen to be vaccinated, your bill does not restrict that. Is that correct?
That's correct.
Thank you.
Thank you.
Thank you, Mr. Chairman, and thank you, Chairman Zachary, for bringing this forward. The vaccination, and it's a good bill. First of all, I was vaccinated. I was had both shots. I was boosted. Still got COVID. So just because somebody has a vaccination doesn't mean that they're not going to get it or spread it. And so I've been through it, and now I have the antibodies. But I think this is a good bill. I think we need to keep all of our frontline healthcare workers working, and I appreciate you bringing this forward. So thank you.
Thank you.
Thank you, Mr. Chairman.
All right, seeing no more.
I did. Thank you, Mr. Chairman. Thank you, Mr. Sponsor. Question on penalties. Are there any penalties in here for either the employer or if the person were to make a claim of exemption and then it's been falsified to some degree? Does this bill address that?
Chairman Zachary.
Thank you, Mr. Chairman. Leader, great question. I'm glad you asked it. So yes, that is addressed in the bill. If you look, and I should have had this marked, there is a section of the bill that, let's see here, make sure I get to the point. Oh, I'll come back to your question quickly, but Mr. Chairman and committee, also something I've received probably 25 to 30 calls from student nurses. I guess there's probably a more official term than that. Those who are going through clinicals, they're approaching their last year, and many facilities are denying them their last year because because of the vaccine. So the students are protected in this as well, just as I was skimming through this. Leader, I want to make sure I get you to the right area here. So in section, I should have had it marked, Leader. Good grief. So in 2E details out the penalty. So there's a $10,000 penalty for any violation of this. And here it is, page 3, section 2. Denial of request for an exemption must be in writing. So if someone denies an exemption request, it must be in writing. The person then takes that denial in writing, takes it to the Attorney General. He reviews the case, and then at his discretion can issue that penalty. So the denial must be in writing. Everything has to be documented. The denial must be in writing. So if they deny, they give it to you in writing. You're providing the evidence that that person needs to be able to take to the Attorney General regarding that fine.
Thank you, Chairman Zachary.
And Mr. Chairman,
You got a follow-up down there,
I
Leader?
want. Is there what is the dollar amount that a person could be civilly liable for this?
Chairman?
Thank you. It would actually be for the facility that denied the
facility.
exemption. That's
Mhm.
$10,000.
And if the person who was asking for the exemption falsely said that they had this religious exemption, is there any penalty to that person? Or how do we verify that that's a true statement by them that they've just signed and given over? et cetera?
Well, I can tell you, Leader, that sometimes it's difficult to see folks' heart with regards to what they truly believe. That's one for all of us to try to stress to be better off. But Chairman Zachary, what say you?
Yeah.
Thank you, Mr. Chairman.
Thank
Leader,
you, Mr. Chairman. I would like to hear the sponsor's response to that.
Thank you, Miss Leader. Yeah,
'Cause
in
there's a lot-
regards to in regards to the medical exemptions, it's got to be signed by a physician. So medical exemption's a non-issue. Regarding the religious exemption, you get in there's Title VII implications related to a religious exemption. So we took the language of Title VII because we're taking Title VII language and then taking it a step further by requiring the exemption be granted. So point number 2 on page 2. Yes, ma'am. Point number 2, page 2, it says that they must attest in writing regarding a sincerely held religious belief. So an example was made in the Civil Full Committee by one of our colleagues who said that his religion was hats. And if he put in writing that we all probably know who that is. He said his sincerely held religious belief was hats. And he was making a point that would be denied because that is not a sincerely held religious belief. So there is a legal definition, and there is a sincerely held religious belief is defined in Title VII. And so that's where, and there are also limitations in Title VII about questioning anybody's request for a religious exemption. So you can't go further than this. There is language related to sincerely held religious belief and then reasonable accommodations. We've all heard that over and over again. That's all pulled into Title VII. And so that's more federal than state. So we simply took that language. You have to be within the bounds of Title VII. Then we're saying that all those exemptions have to be granted.
Thank you, Mr. Sponsor. Representative Hodges.
I can't hear you.
How are we defining medical professional? We're not just allowing anybody that calls themselves, so chiropractors and stuff like that aren't going to be able to sign a doctor's note, right?
Chairman Zachary.
Thank you, Mr. Chairman. Good question. So point 1, page 2, that language, you may be looking at an older amendment. It says a licensed physician is listed under Title 63, Chapter 6 and 9. So you're correct. Like a vet or something could not sign your medical exemption.
Thank you.
Thank you.
All righty, scanning. Representative Sparks.
I just want to thank you, sponsor, for this. I've had nurses and folks work at the hospital the past several months call me about this. I want to thank you. You mentioned blue states dropping some of these mandates. Do you know, I think there was several the past few days, isn't there?
Chairman Zachary.
Thank you, Mr. Chairman. New Jersey, Delaware, Connecticut, New York, Massachusetts, and then cities like Denver that have Democrat mayors have dropped all their mandates.
All righty, now I do not see anybody, so unless somebody's opposed, except Representative Lynn. Good thing you were right in front of me.
Good thing. Mr. Sponsor, thank you very much for bringing this bill. I really love it. When our PEs and nurse practitioners, physician's assistants, PAs, and nurse practitioners included in licensed professional?
Thank you, Mr. Chairman. That's a good question, Representative Lynn. I did not dive deep into Title 63, Chapter 6 and 9, so I don't know. Listed under physician, for those who want to know, it's Title 63, Chapter 6 and 9. So that would detail out those who could sign for a medical exemption.
Now I see, I'm going to close my eyes because I see there's no more questions. Anybody object to calling the question? Any question objections? We are now voting on House Bill 18. We did not, but you know what? You know what, Leader? My high regard for Representative Towns is such that we're going to get back. I want to hear from Representative Towns today. Today wouldn't be the same if I didn't. So Representative Towns, throw some wisdom on us.
Mr. Chairman, I just wanted to make sure your eyes were closed, But in all sincerity, just if a child has a religious exemption, does a child have to sign that document, or
Would it be the parent? Say they're 15 years old, 16 years old. Who would venture out on behalf of the child?
Thank you, Mr. Chair. For anybody under 18, the parent would have to sign.
Under.
Under 18.
Mhm. Very well. Mr. Chairman, thank you.
Thank you.
Third.
Question on the bill at this point. Actually, I've got to say that everybody had a great all those in favor of passing House Bill 1867 on the Calvin rules, please signify by saying aye. Aye. Any opposed, say no. No. The ayes have it. Noes, please register your no with the clerk. And just for a brief moment, I'm going to back up a little bit, and I'm going to allow Chairman Faison just a bit of personal privilege here.
Thank you, Mr. Chair and committee. I don't know if you know this, but Chairman Zachary has a little fan club in here today in this committee. She is here making sure he's all right since he had that wreck and nursing him back to health. Y'all welcome his beautiful wife right here, Holly.
Yes, Chairman Zachary.
Thank you, Mr. Chairman, committee. Since my wife is here, I do appreciate you voting these bills out because that would have been embarrassing to have failed in front of her. Thank you, Mr. Chairman and committee.
I was going to say that's some great pressure performance there, Chairman Zachary. Next up on our calendar, House Bill 1652 by Chairman Howell. All righty, we've got a motion and a second. Chairman Howell, the floor is yours.
Thank you, Mr. Chairman, committee. It's great to be in front of this august body. First time for me. Mr. Chairman, I do have an amendment.
Yes, sir. I believe we have several, the way I read them. Does the last one clean up the first two?
Yes, it does.
All righty. So that is Amendment 013372.
That is what I have.
All righty. We are in sync. Please share with us what's on your heart today, Chairman Howell.
Thank you, Mr. Chairman. The amendment excludes banking institutions that are insured by the FDIC or the National Credit Union Administration, also groups regulated by the Public Utilities Commission, FCC, or the Federal Energy Commission, and all those insurance agencies under Title 56. I have no desire to play in that sandbox with those folks because they're not bad actors and they have plenty of regulation already. What this bill does, which was brought to me, by the way, by a constituent.
By the way, Chairman Howell, let's get this bill in the proper posture so we can start talking about your bill. Do we have a motion and a second? All right, we have the motion and second on the Amendment 013372. All those in favor of Amendment 3, please signify by saying aye. Aye. Any opposed? Hearing none, the amendment is on the bill. Now talk to us about the bill.
Thank you, Mr. Chairman. This bill came to me from a constituent who I was having a conversation with and expressing their frustration about being subscribed unknowingly to situations and no way to unsubscribe. What this bill simply says is if they are subscribed unknowingly, unwittingly, or even knowingly on a recurring renewal basis, that if they subscribe online, they shall be able to unsubscribe online. That's the bill.
Chairman Dan Howell, soon to be considered a prince among men by many subscribers who are unwittingly trapped with no way of contacting the people who are withdrawing money out of their either checking or credit card account. I've got a question on the bill. Any opposition? I'm seeing none. So we are going to call the question for House Bill 1652 to send it on to calendar and rules. All those in favor, please signify by saying aye. Aye. Any noes? Hearing none. You're off to calendar and rules, Chairman Howell.
Thank you, Mr. Chairman.
Thanks for staying with us. Chairman Howell has exhibited the patience of Job. He has absolutely worked through this and amended and working with all his people. So we appreciate that. Next up is House Bill 1946 by our own Chairman Haston.
Thank you, Mr. Chairman. The origins of this bill came from a letter I received a few years ago from a real estate company, out-of-state real estate company, cleverly named Delegated, offering $10,000 for 50 acres. And so that's where the origins of this bill came from. What it does is it offers consumer protection to those who have entered into a contract to sell real estate via an unsolicited offer through the mail. I did not agree to this contract and try to get out of it later. That's not where it came from. It does two main things, though. It requires the offeror to send a confirmation letter back to the seller and allows the seller to cancel the agreement within 30 days of the receipt of that confirmation letter. And that's what this bill does.
Thank you, sir. As being a licensed real estate professional, I do appreciate the opportunity here to deal with unscrupulous actors. Do we have any questions for the chairman? Vice Chairman Brickman.
Thank you, Mr. Chairman. In recording a mail contract, is there anything in the recorder's office that would signify that this contract came as a mail-in contract or not?
Chairman Hayes.
I think that what we're looking at is once that we have that letter received back from the offerer, that would be enough to stipulate that this is proof of how this contract was entered into. In the stipulations, it says the offerer sends a mail letter to the offeree that confirms receipt of the signed agreement or contract, describes the offeree's right to cancel the agreement or contract, describes the manner by which the offeree may cancel, and states the date by which the offeree must cancel. I'm not for sure. I don't think that it would be recorded in the way that you're asking, but if a seller was looking for documentation or proof, they would be getting it back in that receipt.
And it's my understanding that contracts aren't recorded at the recorder's office anyway. They only handle the deeds and easements and things such as that. So I don't know how we would have a county recorder handle such a case.
But a deed would follow that.
Right, the deed would follow.
I'm fine.
All righty. Thank you, sir. I'd heard someone call for the question down there before I saw Vice Chairman Bricken's hand. We are going to honor that call for the question. All those in favor of passing House Bill 1946 on to calendar and rules, please signify by saying aye. Any opposed? Hearing none. You are off to calendar and rules, Chairman Hayes.
Chair.
And today's batting cleanup in today's commerce calendar is the one, the only, Representative John Gillespie with House Bill 1727. Motion second. Welcome to the podium, Representative Gillespie.
Thank you, Mr. Chairman and committee. This bill, 1727, is a bill offered by the Comptroller of the Treasury. First and foremost, this bill makes government work better by updating the utility laws and streamlining processes for said utilities. Two specific items that it addresses is, one, it would require water utilities to put their water loss reports in their annual information report instead of in their audit. This just makes the comptroller's job a little bit easier for them. And secondly, it addresses a loophole in the training for those utility board commissioners. Right now, they're required to take certain amounts of training, but they're also able to run for reelection or be reappointed without taking said training. So this just fixes or closes that loophole. And with that, I take any questions from you, the committee. Thank you.
Since Representative Gillespie has so generously offered to answer any questions that we might pose to him, do we have one? Yes. Speaker Johnson has some information he needs from you, Representative
Thank
Gillespie.
you, Mr. Chairman. Representative Gillespie, how does this affect septic tanks?
Thank you, Mr. Chairman. Mr. Speaker, I can have someone from the comptrollers come up if you'd like to hear specifics till
Mr.
that.
Mr. Chairman.
I'm sorry. I'll be right with you, Mr. Speaker, but Representative, we don't have anybody on our list to testify. So we'll be counting on you for all information with regards to this bill. Speaker Johnston.
Representative Gillespie, have you experienced a lot of problems in your district with septic tank problems?
Representative Gillespie.
No, sir, not me specifically.
Okay. Thank you, Mr. Chairman.
Thank you. Seeing no other questions from our panel, we've got a question on the bill. All those in favor of sending House Bill 1727 on to calendar and rules, please signify by saying aye.
Aye.
Any opposed? Hearing none. 1727 will be on its way to calendar and rules. And that concludes our scheduled calendar for today, but that does not conclude our time together. We will be heading out of session to finish up our remedial work on utilities. Representative Gillespie, are you causing problems up here on the dais? Please. We do have a sergeant at arms down here. Thank you. We will conclude our tour of the utility regulatory landscape by hearing from the Tennessee Public Utilities Commission folks today. I myself have been have learned a lot. I'm sure that some folks who knew more than I did have had things refreshed in their minds, but just so that we know, just a word of reminder about what's going on in the real world while we're talking about utilities is that from the home front, City of Memphis mayor this weekend floated the idea of the sale of the largest public utility in the country in an effort to provide capital to make investments for underground utilities in an effort to deal with power outages. And might I remind our body that the Municipal Power Association, TVA, did point out the fact that if that was indeed the case, they would not be regulated by TVA, and there is not a body that would regulate them under that situation. So it has been timely that we've had these discussions based upon what's happening in the world around us. And so with that, we are going to get to know our folks who regulate it's privately owned, even though they may be held by a publicly traded company, but I guess we should say investor-owned utilities. That's the right nomenclature. So again, we are out of session, and we're going to hear from the folks from TPUC. If y'all would introduce yourselves and share with us some information.
Good morning, Chairman Bond and committee members. I'm Earl Taylor, Executive Director of the Tennessee Public Utilities Commission. Tim Swartz, Director of Communication, and Joe Shirley, Director of Utility Audit and Compliance, are joining me here at the table. Kelly Grams, our General Counsel, and David Foster, Director of our Utility Division, are here as well. I regret that I could not be here last week due to COVID, and I was still quarantining, but I'm very pleased to be here today. And thank you for the opportunity for us to share the Commission's role as it relates to the oversight of Tennessee's utilities. Our mission is to ensure safe and reliable provision of public utility services to the citizens of Tennessee. To achieve our objective, we rely on folks like David and Joe, who have over 75 years of Tennessee-specific utility rate-making experience. That division alone has over 250 years of experience combined. We're very fortunate to have highly qualified individuals involved in the complex rate-setting process. All that experience coincides with our over 100 years of statutory history and utility oversight. With that said, I'm going to turn it over to Tim and Joe. Tim will share more about our history, our structure, and our jurisdiction. And then Joe will provide some detail regarding the rate setting process and its unique complexities. Tim?
Thank you, Earl, Chairman Bond, members of the committee. It's a pleasure to be here today, and we appreciate the opportunity to share more about our role as it relates to utilities and the landscape that utilities have in Tennessee. I'll start out by talking about the history of the commission. Every state has a utility commission. We are no different. We are a creature of the legislative branch, so we carry out the functions as directed by the legislature. We have a unique structure. We were originally established in 1883 to regulate railroads, to make sure the rates that the railroads charged were just and reasonable. That same issue continued as technology evolved and industrial revolution, that sort of thing, when we utilities came into fruition and we became the Railroad and Public Utilities Commission. So just like the rail with utilities, we were making sure that those rates were just and reasonable. And as you see on this slide here, I mean, the times change and the Utility Commission has changed structurally and functionally. In 1996, we became the Tennessee Regulatory Authority. Previously, the commissioners were elected statewide. With the change in 96, they became appointed. They were appointed by the legislature and the governor's office. And then more recently in 2012, we were modified yet again and went from a full-time directors to part-time commissioners and creation of an executive director to handle the day-to-day operations. Previously, the chair of the commission or the regulatory authority was also doing day-to-day management of the agency. So, and then most recently, last session, we were expanded to add 2 more commissioners. So now we have 7 commissioners. 2 are appointed by the governor, 2 are appointed by Lieutenant Governor McNally, and 2 are appointed by Speaker Sexton, and 1 is a joint appointment by all 3 appointing authorities. And here's the slide with the 6 commissioners that are currently serving right now. They represent a diverse group representing all 3 grand divisions. And we are waiting 1 more appointment, which should be happening here soon from what we've been told. So looking forward. And with that change, in 2012 is Earl Taylor, who's to my left. He has been our one and only executive director handling our day-to-day operations. And I have to say that we've had a lot of continuity with his presence and things have been working really well under his leadership and hope that continues moving forward. Next slide is a snapshot of kind of our organizational structure. It covers like all of our different responsibilities. We have rate making, we do audits, a lot of consumer different services, gas pipeline inspections. We have 48 filled positions currently, so we're a smaller agency, but with a lot of responsibility. And we are self-funded by the utilities that we have jurisdiction over. We also have some programs that are funded through program fees, and we also receive some federal grants to provide some delegated federal responsibilities. And we have a broad statute that defines what is a utility in this state. This slide covers just about everything you can think of. And then our statute also gets a little more specific. We describe what exactly is a utility for purposes of the Utility Commission's jurisdiction. So as Chairman mentioned at the beginning, we are primarily involved with investor-owned utilities. These are monopolies, privately or shareholder-owned, that are providing utility service to the state. Some of the investor-owned utilities, the larger ones that we have jurisdiction over, include Kingsport Power, Atmos Natural Gas, Piedmont Natural Gas, Chattanooga Gas, and Tennessee American Water. We also have a number of smaller water, wastewater, gas utilities that are across the state. So we cover urban and rural areas of Tennessee. And we provide service, or these utilities provide service to over 500,000 households and 63,000 businesses and institutions statewide. And we also, our definition of utility also describes what is not a utility for our purposes of jurisdiction. And as previous presentations have mentioned, we do not have jurisdiction over cooperatives, the municipal systems or utility districts. And the statute also does not give us jurisdiction over broadband. Although with some of our telecommunication institutional knowledge from prior years, we do serve as a resource to TASR and ECD as they try to provide the mapping for broadband and administering state grants. So we do have limited telecommunications oversight anymore. 2009, there was market regulation that was passed, which really kind of changed, I think, with the internet and everything else really taking off. There wasn't as much of a need for the commission to set the telecommunication rates. But we do retain some jurisdiction. We resolve disputes between the carriers, and we review interconnection agreements. And then from time to time, when regions exhaust their area codes, we participate in that process to add new area codes. We also are the delegated authority for doing gas pipeline safety inspections across the state. There's over 69,000 miles of transmission and distribution lines with service to over 1.4 million customers. The commission has 6 dedicated inspectors on staff, and we do over 700 inspections a year. I might add also that if it's a municipal system or a cooperative or a utility district that provides natural gas service, that is the only way the utility commission would have any, the way we would touch those utilities would be through these gas inspections. Otherwise, we have no jurisdiction there over those utilities. And we also provide some other services, such as if cable operators, if they're seeking a statewide franchise, we review those and provide those approvals. We also provide administrative and investigative support to the Underground Utility Damage Enforcement Board. That is affiliated with the 811 nonprofit Call Before You Dig. So it's a permissive complaint-driven program designed to improve public safety and reduce underground utility damages. We think it's been working really well thus far. We're about 5 or 6 years into this program. And we also do not call. We regulate or manage the telemarketers in the state. And we also provide services for the hearing impaired so that they may communicate where traditional methods won't work. And I just covered telecommunications briefly. And what I thought I'd do is just turn it over to Joe, who can expand more on the rate-making process and kind of let you know how that transparent side of the operation, how that works.
But while Joe's getting ready, I do want to point out, so you're in charge of the do not call list is what I just heard you say. So if we're getting, some are slipping through, we can call you, Tim?
Please do, yeah. Most people do call me anyway for that, but we don't handle spoofing. We do have a sister agency over in the AG's office that handles a lot of the spoofing matters. But if it's involves a telemarketer who's not following the do not call list, then we can take an enforcement action.
All righty. We'll cease our interruptions.
Okay. Well, thank you, Tim, and good morning, Chairman and members. I just want to talk with you briefly and kind of focus on some of the more core responsibilities that the commission has and kind of go into those. You can see from the slide that we generally have 4 major areas of responsibility. The first one I'll address is our issuance of certificates of public convenience and necessities, or CCNs, as we call them. And essentially, if an investor-owned utility wants to provide a public utility service in the state, they have to come to the commission to get authority to provide that service. And what we'll do is we'll take a look at the applicant's technical, managerial, and financial capabilities to serve the public need. And assuming that all that checks out, then a CCN is issued to that utility. And the granting of that CCN essentially gives that utility an exclusive franchise to serve the particular area that they're authorized to operate in. The next thing on the list is our rate setting authority, and I'm going to go into that in a lot more detail here in just a minute, so I'll jump over that one for a second. The third on the list is enforcement. Of course, the commission has the responsibility for enforcing its enabling statutes and rules, and so that is a function that we do. And last on the list is our complaint resolution process. Essentially, there's kind of two categories here. We may hear complaints from customers of these investor-owned utilities that we regulate. Occasionally, but a lot less frequently, we may have a complaint maybe if two of our regulated utilities get into a dispute. There's a process for these utility-to-utility complaints that we may hear. That's a lot less often. What we try to do in all of these complaint cases is to try to mediate those complaints first, investigate and mediate. If that doesn't work out, however, there is a formal complaint resolution process that we would follow to resolve the matter. So I wanted to get back to our rate-making authority, though. That's kind of seems to be, one of our bread and butter things that we do and kind of the primary focus of the commission and a lot of the concerns. There's essentially two tracks here. We have traditional rate-making, and more recently we have newer alternative rate-making methodologies. I'm going to cover both of those. And when I'm speaking of rate-making, whether it's traditional rate-making or alternative rate-making, what I'm talking about, as Tim mentioned, our investor-owned utilities serve around 500,000 households in Tennessee, around 63,000 businesses and institutions across the state. So when I'm talking about rate making, I'm talking about setting the retail prices that those customers have to pay for their public utility services. So I want to talk about that process. Now, our rate setting authority in that area really only covers 4 services. We set the rates for electric, natural gas, water, and wastewater utility services for investor-owned utilities. So when it comes to any other type of utility services or any other utility companies, we do not set rates there or have any rate setting authority over those services or entities. And generally, this rate setting process is started most often by a public utility coming to the commission and requesting a change in rates, usually a price increase. And that's generally how it happens, although the commission, we do monitor the costs and earnings of the utilities that we regulate. And the commission does have power if after a hearing, the commission determines that the current prices are unjust or unreasonable, the commission has the power to reduce rates. That has happened more in the distant past, but it's something that really doesn't come about too often, but that is within the commission's authority to do so. And when we're talking about rates, just and reasonable rates, that's kind of the poll star, the standard that we use to determine what rates should be. There isn't any particular formula or method, though, that we have to use to determine rates. But there is an overall framework, right, of utility rate making laws and rules and principles that we have to operate within. So, for example, the commission couldn't set or require a utility to provide service at an unreasonably low rate, right? Because that would be considered a confiscatory rate. And essentially what that would have the effect of doing is taking the shareholders' investments in the enterprise and putting it to public use without just compensation. And of course, then we start running afoul of, these constitutional takings provisions and things of that nature. So there is this framework that we have to stay within. And within that framework, though, there's a lot of judgment, of course, that we have to exercise. There's a lot of issues to be considered. And so in doing that, the commission really has to rely on its collective rate-making experience and specialized knowledge of the industry to determine what these rates should be. And one other thing I want to touch on about just the general process is the balancing of the interest. And this really is kind of the focal point of what we do. We have to balance the customer's interest in receiving public utility services at reasonable prices against the shareholder's interest of making a fair profit on their investments in the enterprise. And so those are kind of the competing interests that we have to balance in this process. And that really is, like I said, one of the focal points of the regulatory work that we do. With regard to the process that we use to set rates, the commission is a UAPA agency. So our process is governed by the Uniform Administrative Procedures Act. That means that when we set rates, we have formal rate hearings under that act. And the utility companies, they're represented by legal counsel. They have expert witnesses that present information and testimony with regard to their positions. We also allow under that process any other interested party to intervene and participate in the rate hearing. Here, the Consumer Advocate Division of the Attorney General's Office, they most often participate in these rate proceedings to represent the residential and business customers of the utility that's requesting a rate change. There's also other interested parties that may less frequently intervene. For example, we've had manufacturers associations and other consumer groups like that to intervene and participate in hearings. Now, as a part of the process, the parties during the rate hearing, they're allowed an opportunity to gather information from each other through the discovery process. But once that is done and the parties submit all of their testimony and exhibits and support for their positions, that's when we'll have a panel of 5 of the 7 commissioners will sit and hear all of the proof in a formal rate hearing. These rate hearings are given public notice, of course, and any member of the public can also appear and make comments as a part of the hearing process. And this next slide will just kind of give you a diagram maybe of how a rate case proceeds. And if you look at kind of like the bottom right 2 boxes there, after we've had the formal rate hearing, the commissioners will then convene a public meeting where they will deliberate and decide the case by majority vote. Of course, the commission staff are acting as advisors to the commissioners during this process. The decision is then formalized into a final written order, and any party that's dissatisfied with that order may appeal from it. And interestingly, the commission's appeals are taken directly to the middle section of the Tennessee Court of Appeals. And then our legal staff then would defend the commission's decision on appeal. I do also want to mention here that at any time during this process, the parties to the case may settle the matter. And so these settlements often involve the utility entering into settlement agreements with the consumer advocate and any other parties that are in the case, where they essentially produce agreed upon rates in terms of services through a settlement process. They will then present that to the commission. The commission will review the settlement, and if it's in the public interest, the commission will approve the settlement as a way to resolve the matter without having to go through all of the formal hearing process. We certainly try to encourage that process, the settlement process, and we've had a very good track record of cases being settled. 3 of the last 4 major rate cases have ended in settlement. Now that I've covered kind of the procedural parts of rate making, I want to talk a little bit more about the substantive aspects of rate making. And this really kind of applies to both traditional and alternative rate making. But there are several aspects to this. First of all, the commission sets rates based on a forward-looking methodology. So we're taking forecasts and projections and trying to set future rates that are just and reasonable. And with regard to this forward-looking methodology, there's several different aspects to this. Okay, so not only is historical and current information certainly relevant, we need to review that, but we also have to look into anticipated or expected cost drivers as well. And so, maybe a utility's business plans for expansion due to customer growth in its service area or economic development in its service area, those things must be considered because that certainly can affect costs. Utilities' infrastructure needs, maybe expansions of plant to meet customer growth, or it could be infrastructure development or investments that's needed to comply with certain safety and environmental regulations, or maybe just to modernize the plant or replace old plant that's outdated. Those things certainly have a substantial bearing on cost. So their infrastructure and capital budgets certainly play a major role. And then other items could affect our analysis here too, such as consolidations or business reorganizations. And so I guess the point I'm trying to make here is that we do examine, of course, a lot of financial data with regard to the rate setting process, but it's much more than just a mathematical exercise. And so we have to really take a look at the individual utility and tailor the rate making process to that individual utility's operations and to the particular needs of the service area of that utility. But so that's the background. Looking at the rates, the basic rate elements, of course, is with the green circle there. We have to consider what the utility's anticipated revenues are going to be. So, to determine whether or not there's a revenue deficiency, of course, we have to take a look at what they're currently getting. And that's from all of their customers, from their, residential customers, their business customers, even their very large manufacturers and industrial customers. All of those revenues are analyzed to determine what the revenue picture is. Of course, the operating expenses is a big driver of costs. That would include items such as personnel costs, certainly the maintenance and repair of utility plant is a big consideration, as well as depreciation recoveries of the plant investments that must be considered. There's a lot of other cost items that could be considered here under operating expenses. For example, allocated costs to Tennessee. A lot of our utilities operate in multiple jurisdictions. So if they have headquarters or service companies that are not in Tennessee, but they are allocating costs to Tennessee, then we have to take a look at that to make sure that just the Tennessee jurisdiction is getting its fair share of costs and part of our rate making process. Taxes is another big consideration. Utilities, do have to pay taxes, income taxes, payroll taxes, and of course, ad valorem or property taxes on all of that plant investment is another big tax driver. So that has to be built into the rates. Interest on debt is another consideration. Most of our utilities have a substantial amount of both short-term and long-term debt to capitalize the company. And of course, the reasonable cost of that debt is recoverable from customers as well. And then the last big element of rates that I want to discuss is the shareholder returns. And shareholder returns, of course, there's a lot of judgment maybe that's being at play here, but we're trying to determine what is a fair compensation to the shareholders for their investments in this utility enterprise. And that's often a pretty well debated issue when it comes to these rate hearings, but we certainly do hear from economists and other experts as part of the rate making process. Take that information into consideration when we're trying to determine what a fair rate of return on equity to the shareholders would be. So those are the basic rate elements. Of course, the commission, we certainly want to maintain affordable rates to the extent we can, but we also want to have financially healthy utilities, right, where they are able to cover their reasonable costs and the shareholders can earn a fair profit on the returns, because that financial stability of the company is what keeps the utility viable and serving the public need going into the future. And again, it kind of gets back to that balancing of affordable and reasonable rates for the customers and the fair return to the shareholders for their investments in the enterprise. So that's kind of a look at our traditional rate making and the major rate components that goes into building customer rates. I want to take just a few minutes and cover alternative regulatory mechanisms. These are alternative methods for setting rates. We refer to these alternative regulatory methods as ARMs, so I'm going to just kind of refer to them as ARMs here. And these were authorized by the General Assembly in 2013 for the Commission to approve certain alternative methods for rate making for public utilities. And the purpose of these new ARM mechanisms really was to kind of modernize and streamline the traditional rate making process so that the utilities can be able to essentially update their rates in an easier, more streamlined way in order to recover costs without having to go through a traditional, more protracted rate setting process. And these ARMs have been really largely successful. We have approved ARMs for all of our major utilities, and Tim mentioned some of those. For example, Piedmont, Atmos Energy, Chattanooga Gas, Kingsport Power, Tennessee American Water, they all have ARMs that we have approved and that are in operation today. The ARM plans really just kind of falls into three different types of ARMs. We have one type of ARM that really kind of takes a focused look on certain operational costs and capital costs, and it kind of goes through line item by line item, and it allows a company to kind of track a certain bucket of expenses or capital costs, and then recover those specific costs through periodic rate increases, without, again, having to go through the rate making process. And then we have annual rate review as another type of ARM, and that's a much more comprehensive ARM. It's an approach that takes a look at all of those rate elements back here. So in an ARM, we're basically taking a look at all of these in an annual rate review mechanism. And essentially what this is designed to do is to allow a utility based on predetermined methodologies and pre-authorized levels of earnings to keep their rates up to date through an annual filing so that the shareholders can earn their targeted authorized returns on investments. And finally, the third type of ARM that we have would allow a utility to present any type of customized program that it wants to file with the commission for our review and approval. With regard to that first type of ARM, where we're talking about particular line item costs, whether it's operational or capital costs.
Excuse me,
Yes.
Joe, if you don't mind, I've got some questions and I don't want the clock to go out,
Sure.
run out on us. So this is.
Can wrap it up.
Yeah, if you give me a quick wrap up here in about a minute, and then we've got folks who have questions that have built to date, questions too, because I think you have very well demonstrated the fact that there's quite a bit that goes into how y'all determine things. So if you could give us a quick wrap up, and then we'll hit our questions and be done. So
thank you, Chairman, and I certainly will wrap this up in short form. So with the again, these different particular costs that could be recovered through an ARM could be a utility's effort to keep the system safe and reliable. They can also use these ARMs to recover certain infrastructure investments, also to recover certain eligible costs for economic development or other non-discretionary costs certainly can be recovered through these ARMs. I've already talked about annual rate review. This essentially just demonstrates how you can, the requirements for getting into the rate review, and demonstrates that we do review those. And if they need modification over time, there's a process for modifying those annual rate review process. So I think that with that, I'll turn it back over to you and we'll be happy to answer any questions that the
all righty, I'm going to take chairman's privilege here and ask a few myself here. And we have heard from the government-owned utilities that that they're not necessarily regulated on how much retained earnings they hold within their businesses. Do y'all examine that with regards to investor-owned? Do y'all monitor and maintain the retained earnings from these utility companies?
Well, I think our approach is more or less to determine what the appropriate authorized earnings of shareholders should be as a part of the rate-making formula in determining just and reasonable rates. And so that is an analysis that we do, but we're certainly not monitoring or have no really authority over whether or not that company is retaining those or paying those earnings out in dividends to shareholders. Those are company decisions, but we do authorize the level, the amount of earnings that those shareholders are allowed to earn on the operation as a part of the rate-making process.
So that's a level of regulatory review that does not necessarily extend to government-owned monopolies.
That's correct.
Okay, so y'all basically monitor their profit, but nobody monitors the profit of government-owned.
We do not.
Understood. But I guess, okay. And so that's one of the big differences that we're seeing, or that I'm noticed here, is that no one's looking at how much money these utilities are making. They look if they are not making, we're concerned if they're not making money, but nobody's looking to see if they're making extraordinary windfalls or profits. But yet you're looking at that you're keeping the lid on investor-owned.
That's correct. We do authorize the amount of earnings that shareholders can make on the enterprise.
I just find that fascinating, that we want to control how much money and the private sector makes, but we don't care how much money government-owned monopolies make. That seems curious to me. But do you agree that there's not much different, but other than that elephant in the room, is there any similarities operationally between the utilities that you do not regulate and the utilities that you do regulate?
Well, I think when it comes down to the technical aspects of providing the utility services, there's certainly probably a lot of similarities with regard, to the costs and the plant that's needed in order to deliver that service, whether it's a natural gas service or a water or wastewater service. So I'd say that there's a lot of things maybe that's in common with the, providing those services, whether it's investor owned or any other type of entity. There could also be certainly, other cost considerations that we might not factor in on the investor side of things that perhaps another type of utility would. But I would say that there is a lot of shared commonality, though. Yes.
Okay. And again, I'm trying to grasp hold of this, the fact that investor-owned faces more scrutiny than publicly owned. Okay. I guess then that, makes me wonder whether or not we're over-regulating one and under-regulating the other, frankly. That's what you folks that's the thought of my day today, is that that may be the case. The last thing that I want to ask you about is this border supply of utilities. There was something that you said in there about utilities that extend across our state border. I think you'd mentioned one particular case, but in my neck of the woods, there was a situation where a sewer collection system was going to be on the Tennessee side, yet the treatment was going to be in Mississippi. Was that a situation that TPUC would care to have any interest? Are y'all charged to review that, or is that basically an unregulated kind of Wild West scenario?
Well, if it's an investor-owned utility providing service in Tennessee, we would have authority to set those rates. Now, when I was talking about utilities operating in multiple states, generally what I'm referring to is maybe their corporate headquarters, or they may have service companies like customer complaint lines or whatever that are being operated in other states, that we would take a look at the cost allocations to Tennessee. Now, there are a few like utilities where maybe there is a company. We had Entergy Arkansas. They serve maybe a half a dozen or maybe a really small number of Tennessee customers. And essentially, the Tennessee basically concurs in the Arkansas Public Service Commission's rates in those instances, where we might have just a few customers served in Tennessee from an out-of-state utility. That's very rare, though, and when that happens, it's usually just a handful of customers maybe that they have picked up that goes across the state line. So that's essentially how we would do that, is look at the regulation that they are having in other states, like Entergy Arkansas and the Arkansas Public Service Commission rates, is how we review those.
All right, and then what I'm going to need to do here is, Vice Chairman Brickett, I'm going to have to step out for just a brief moment, I will be back, but if you could gavel this, work our questions, and then including your own, and then I'll be back to join you here. I've just got to step out for just a brief moment.
All right, well, I get the gavel and the mic because I was on the next question list. Mine doesn't have to do with rate paying, but it has to do with an operational question. I was reviewing y'all's annual report. I think about 80% of y'all's revenues come from inspection fees. I don't know what the total annual revenues the commission receives, but my questions are this. Do y'all set your inspection fees to cover the self-funding cost of your commission? Do you have excess revenues, and are those excess revenues going into the general fund of the state?
When we have excess revenues, we have a surplus fund, and we use that surplus in instances like a couple of years ago. There was a utility in near Crossville that went out of business, and we had to spend about $1 million of that surplus to help them transition from their entity to the Crab Orchard Utility District. So that's rare, but that's why we maintain a surplus. What was the rest of your question? With the first part, we get monies, the fees that are paid by the utilities, that's set by statute. So that's 85% of our revenue. And then we get some revenue from the federal government, like our Gas Pipeline Safety Division they provide 80% of the monies that we spend in that division to maintain gas pipeline safety from Mountain City to Memphis.
And do you know roughly what your surplus fund?
I think it's around $6 million.
6 million. All right. Thank you. Next question is Chairman Hazelwood.
Thank you, Mr. Chairman. Just as we are dealing with inflationary pressures pretty much across the board, just curious if you all are seeing any activity in terms of requests for rate increases based on increased costs of operations of the utilities that you oversee.
Well, certainly costs are on the rise, and we've seen some of those requests for rate increases. Kingsport Power has a pending rate case now. We have other companies that through the annual rate review mechanism, the alternative rate mechanism that I discussed earlier, that annually file for rate increases. So we do see rising costs.
Could you just give us a ballpark of the percentage, typical percentage of those rate increase requests?
I would be a little bit hesitant to talk about specifics. I certainly could get you that information in more detail. If you could just let me defer just a second.
Or just as kind of an average, I'm not trying to ask specifically regarding a particular utility.
So I think, around 10 to 15% usually is what we're seeing. Now, I know there's probably a lot of concerns right now, particularly with natural gas prices and really high winter heating bills. There is a kind of a distinction to be made here. The commission doesn't set the price for the natural gas commodity. That's driven by the market. And a lot of that gas is delivered to Tennessee from the wellheads, most of those being located in the Gulf of Mexico over like interstate pipelines. We do not control the price or the charges for transporting that gas from the Gulf to the Tennessee service area. Those are set by the Federal Energy Regulatory Commission. FERC governs the rates for the interstate pipeline. So we're just setting, for natural gas companies, for instance, we're just setting the amount, that the percent of the customer's bill that the company charges for distributing that gas locally. But the cost of the gas and the cost of transporting the gas to Tennessee, we don't control the prices of that, although our local companies do not make any profit on that either. So they're only allowed to flow that through to the customers at their costs. And we do a series of annual audits every year to make sure that those costs are being flowed through appropriately. So a lot of the costs of the natural gas customers, for example, and this relates also to Kingsport Power too, in some regards. A big portion of that bill really is set by the market or by the FERC, and it's not within our jurisdiction to set the rate for that. And so a lot of the bill in the wintertime, that can be the majority portion of a customer's bill, maybe 70–80% of the bill could be costs that are being flowed through that we have no rate setting authority over.
Again, I think the only reason I even bring up the point is to just underscore and reiterate that inflation is real and it's impacting every aspect of Tennesseans' lives and all of our pocketbooks. And some of the folks who can least afford it with fixed incomes and that sort of thing. And energy is just a huge part of, you've got to stay warm. There are a few things you've got to do. So again, thank you for your oversight. But as we're looking at budgets and all those sorts of things, I just want everybody to remember, I said this in finance, I'll say it again here, $1 billion doesn't buy as much as it used to. And we just really have to remember that. Thank you.
Thank you, Chairman Hazelwood. And I'm going to take Chairman's privilege one more time. And I just to clarify, y'all regulate utilities, investor-owned utilities, rates and operations. Y'all don't also wholesale them their product, do you? Just clarifying that y'all are not selling anything to these people you regulate. They're not your customers.
Correct.
I want to make
That's
sure I had that
correct.
correct.
We're just setting the retail prices that those customers.
Understood. Representative Towns, I saw you this time. I had my cheaters off.
I understand, Mr. Chairman. Gentlemen, thank you all for the presentations. A lot of stuff in here, quite a bit of stuff in there. And I wish you had more time to ask questions. One of the questions I have for you, when you talk about inspecting thousands of miles of pipeline and this, that, and other, does that also include in your inspections the transportation of oil in pipelines, or is it just natural gas?
I believe it's just natural gas.
So what would happen is that if there's some kind of leak or something, you all would catch it and hopefully we get some kind of quick remedy to stop it.
That's it. That's the goal.
Well, the same thing can happen with oil pipelines as well. Why aren't we not dealing with oil pipelines that run through our state? And that oil messes up water, thousands and millions of gallons.
My understanding is that's just not under our purview.
That would be something that I would be very, very anxious to see if we could maybe have you all to look at. Okay, because at the end of the day, what we all have to have is good, clean water for our food and for our, crops. Food, same different than drinking and bathing and what have you. It's very, very critical. And as I've learned, any of that oil that gets into any water contaminates millions of gallons of water. Just 1 gallon can, So that's something I think we should look at because as Murphy's Law goes, anything that can happen, go wrong, sometimes it just happens. God forbid, but it does happen. And hindsight is always 20/20, but it's too late. It's too late.
Let me get back to you and we'll find out who regulates that, who looks at that, and we'll get back to that.
Would you please?
Yes, I will.
That concerned me greatly. The other thing I'd like to echo something that my chair lady said that, $1 billion doesn't go for these days. It's just not a lot of money anymore, even though I don't have it. But I'm working on it. They take me 2 lifetimes. But the deal of it is that that's very important. Thanks for the work that you do. Thanks for the presentation. I did have some more questions, but I'll defer it. See if other members have something.
Thank you, Representative Towns. And what we're going to do is we're going to go to Representative Lynn, and then we're going to go to my good friend from Rutherford County to take us home after that. And I see Representative Calfee's back. You're still inquisitive? All righty. Well, I always like to clean up with my friend from Rutherford County, so we're going to go Representative Lynn, then Representative Calfee, and then Representative Sparks.
Thank you, Mr. Chairman. I'm just curious, when doing rate cases, do you all take into consideration affiliated suppliers? And I ask because a number of years ago, there was a rate case. A lot of suppliers, it was in my district, and a lot of suppliers came to me and said that the utility only used affiliated suppliers. In other words, they owned all the suppliers. Naturally, they're before you with a rate case, so that price that they're getting from their suppliers may not actually be market, and that's what these other suppliers were claiming. So is that taken into account when a rate case is performed?
Yes, it is. That's a short answer. And, we don't restrict any of our utilities, of course, from doing business with affiliates. But certainly we take a look at those affiliate transactions to make sure that they're look like an arm's length market-based transaction.
Right.
And we have affiliate rules that are in effect for certain of our utilities.
Awesome, great answer. And then the second question I have, when there are jurisdictional issues, in my district, one of our suppliers, one of our utilities regulated by you all was in conflict with the city's urban growth boundary, and the city said they wanted to hook up the sewer and they had domain in the urban growth boundary, and the utility claimed, no, we have it in statute that this is our territory, you can't do that. Well, the city did consult their attorney. They felt very strongly that they were in the right, and they just went ahead and hooked up the sewer, even though the utility said, we're going to sue you. They didn't. But when there are jurisdictional issues, it seems like there ought to be a better way to settle that. Is there a way?
Well, that occasionally we will have those types of issues where you have one utility that's been granted an exclusive franchise to serve a particular area, and maybe they are unable to serve that area or not serving that area, and someone else maybe wants to come in and serve a part of that geographic location. We've had that, or we've had maybe instances where a utility in a city are in maybe a dispute about whether or not who has the right to serve a particular area. Those cases can come before the commission to be decided. It's very rare that they do arise, but if that is filed before the commission, there is a process for the commission to review and determine that. Again, it's very rare that that happens.
All right. Thank you. Representative Calfee, we're getting late in our hour.
Thank you, Mr. Chairman. Sorry to leave. My calendar said I had a meeting with the comptroller, but that was yesterday. So anyway, last week, I believe it was, we had a presentation from TVA, and there was some heartburn about the fact that they regulated the people that sent them the revenue. Where do y'all get your revenue?
Well, I think
The utilities that we regulate, as the bulk of it, we get some from the federal government to administer the gas pipeline safety division, and also the deaf-blind distribution program. So 85% or so of our revenue, the fees that come from the utilities that we regulate, and those fees are set by statute.
So that's no different than, sorry.
Yes, sir, Representative Calfee.
That's no different than the situation with TVA and their customers, right?
Ooh, I would object. I would question that because they're selling wholesale power to their customers. These gentlemen just clarified they don't sell any product. They just merely collect fees.
But you regulate those that pay you the fees, right?
We set the rate.
What? I'm sorry, I didn't understand that.
We set their rates, the rate that they charge the retail customer.
Okay, sorry I brought it up.
No, I think that's a very clear distinction. I think your question is very pointed, Representative Calfee, is the fact that we set the statutes that require the utilities to pay these folks their operating expenses. And so they are the source of the funds, but they don't sell these fellows don't, or ladies and fellows don't sell a product to the utilities. And that's the between that's the difference between TVA and, in my eyes, that's a distinctive difference. But your point is well made. All right, Representative Sparks, only you can conclude our series on regulations.
Thank you.
Take us home.
Thank you, Chairman, and thank you. I appreciate your passion for this because this stuff affects our constituents every day, every day. Just this morning, I was driving in, stuck in traffic on I-24, and called my brother down in Dallas. I'm like, hey, how's things going? You know, I know there was some utility problems down there, and Memphis was without electricity here. 2 weeks ago, I guess. My assistant's mother was out without electricity, and they do a lot of wind power down there, and I guess some of that froze up. But you know, I'm seeing fuel going up, natural gas prices going up. Sometimes I think it's done on purpose. That's a theory that I have. Part of your goals here is to decrease the cost of regulation. Can you tell me what is being done to decrease the cost of regulation?
Okay, well, I think, as I mentioned earlier, we have a lot of alternative forms of regulation, rate setting now that has really kind of newer types of regulation that was authorized by the General Assembly actually in 2013 to streamline and modernize the rate setting process. And so it essentially allows a utility to come in with an annual filing to keep their rates updated rather than having to, you know, wait over a period of sometimes years and come in through a really long, large, protracted general rate case proceeding in order to establish rates that may then have to be sufficient for the next few years. So
Yeah.
I think the alternative rate making form, it allows us to look at the utilities that we regulate kind of on an annual basis to keep things up to date.
Yeah.
So
Y'all don't TVA sets pole attachment fees, right? Not y'all.
We don't.
TVA sets those.
We do not.
Okay. Well, it just seems like and I know I probably vent to maybe the wrong people, maybe it's TVA, but you know, you see, it seems like an attack on fossil fuels, and you know, you hear constituents that are hurting, grandparents raising grandkids now, and you see a lot of turmoil in your districts, or we do. But I think this is something we need to keep up, Chairman, and I appreciate your passion. I don't think there's enough discussion for solutions in the General Assembly, and it's hard to grasp my head around all this, and I think it's difficult for everyone. So hats off to this committee and the chairman for taking on that challenge.
Thank you, sir. And for all who are still here, I'm noting every one of you who have stayed through and taken us to the end of this today. So anyway, thank y'all for coming today. T-Puck, we have actually worked overtime. I'll turn that in on all our time cards. And we are going to go back in session simply so we may adjourn till next week.